Recording. I would like to introduce Keygan Miller, Ming Wong, and Troy Stevenson for this presentation. You folks can take it away.
Awesome. Well, we're gonna be talking about knowing your rights today, and I believe, if I'm not mistaken, that my colleague Ming is going to kick us off talking about implications of the Bostock decision.
Yes, but maybe we could introduce ourselves a little bit too, just so that folks know who we are. So I can start us off and then hand it off, and then after that, I'm happy to talk about Bostock and all that good stuff. So I'm Ming. I'm the supervising helpline attorney at the National Center for Lesbian Rights. I've been at that job for 12 years now. Most of that job entails responding to calls for legal assistance from around the country. We get about 1,500 calls every year on a whole range of topics. So I'm very happy, and I have become a little bit of a generalist as a result of having to answer all these legal questions all the time for 12 years. So I'm very happy to be here and get to do a Know Your Rights. I think we're going to focus mostly on discrimination. But I'll turn it over to maybe Keygan. You want to go?
Sure. My name is Keygan Miller. I use they, them pronouns, and I am an advocacy associate at the Trevor Project. My main focus area is around school policy prevention and around suicide prevention and other school-based LGBTQ issues. Troy?
And I'm Troy Stevenson. I use he, him pronouns. I also work for the Trevor Project. I manage all of our conversion therapy efforts to ban conversion therapy around the country and in Canada, and also other lobbying aspects that the organization does.
Great. Okay, so I will get started. Oh, sorry, I should say one more thing. I really appreciated the land acknowledgement at the beginning of this whole conference, and I should say that I am calling in from Oakland, California, which is the land of the Chochenyo Ohlone people here, and their language group within the broader Ohlone people in the Bay Area. So with that, Bostock. So Josh just talked about this case actually in his presentation, which I'm so happy about. So the case, I'll give a little background on the case itself. This was a case at the Supreme Court. It was decided this summer, 2020, in June. Sorry, let me look at my notes one more time. So I'll say the big quote from this case that is the important one and has all these like huge implications for many other areas of law besides employment is, it is impossible to discriminate against a person for being homosexual or transgender without discriminating against that individual based on sex. So that line from the decision has huge implications for many other areas of law besides employment. So this was an employment case. It actually decided 3 related cases. The title case, Bostock, involved a county employee, Gerald Bostock, in Georgia, who was fired after he joined a gay softball league. They found out that he was in this league. They fired him. They claimed they fired him for misconduct, but he said that was just a pretext. And then also in their defense, the county said, well, even if this was a pretext, it's okay for us to fire you because you're gay, because that's not covered under Title VII, which is the federal anti-discrimination law. So that's one of the cases. The other 2 cases, one of them involved an employee named Donald Zarda. He was a skydiving instructor in New York. He actually he noticed that one of his clients was feeling uncomfortable being strapped to him, as you do when you're teaching somebody how to skydive, and told her that he was gay to try to reassure her that he wasn't going to do anything inappropriate. She complained that he had told her that he was gay, and he got fired by his employer. They again tried to get the Title VII claim dismissed because they said, well, it's okay for us to fire him because he's gay, because the law doesn't say that we can't. That happened in 2010. And then the last case is involved, it's called the Harris Funeral Homes case. It involved Amy Stevens, who was a funeral director in Michigan. And she was a trans woman. She had been working at the funeral home for, I think, 6 years at the point when she came out to her colleagues, and her employer told them that she could no longer, that she wanted to live openly as her authentic self, and would be coming back to work. She took a break, and then she would be coming back to work as Amy. When her boss found out, he fired her. They did not bother to try to hide the reason why they fired her. They said it was very clear that they were firing her because she was trans. That case also went up, and all 3 cases were decided in one opinion at the Supreme Court in Bostock. I'll share like a small sort of sad fact about the other 2 cases actually. Neither Don Zarda nor Amy Stevens survived to see the Supreme Court decision. Don died in a base jumping accident in 2014. So after he was fired from his skydiving job, he switched over to do base jumping, which my understanding is it's actually a much riskier activity than skydiving. And he did in fact die in an accident from that. And then Amy Stevens died of kidney complications from a kidney failure. And she died just the month before the Supreme Court decided in her favor in May of 2020. And I'll add one sort of awful fact about her situation is that, as she was getting sicker, her family was forced to start a GoFundMe to cover her end of life costs, in part because of the financial strain from her being fired from her job a few years earlier. So I just like to give a little bit of the human stories behind the Supreme Court case to show that, although the Supreme Court decision was very much based on a very sort of legalistic idea of what is the law, what does the law say, that there are these human stories behind it that show the importance of protections for the LGBTQ community in employment law. So the case itself, the opinion itself, was written by Neil Gorsuch, who was appointed by our current president. And it was a little bit of a surprise to some people because he's seen as a conservative. But the opinion actually is very in line with his strain of judicial thought, which is to look to the text of the statute to determine what it means, and to try as much as possible not to look at anything else. And so he read Title VII, and we think very reasonably, which says you cannot discriminate against somebody in employment on the basis of sex, to kind of by logical deduction just from that language to cover sexual orientation and gender identity as well, because it's impossible to think about sexual orientation or gender identity without thinking about an employee's sex. It's just conceptually impossible. And that's what the opinion really focused on. And because the great thing about having an opinion that focused so much on the language of the statute is that there is similar language in a whole bunch of other federal discrimination statutes, right? So Title IX, for example, of the Civil Rights Act, which applies anti-discrimination law to schools, has a very similar thing about you cannot discriminate on the basis of sex in education. The Fair Housing Act also prohibits sex discrimination. Section 1557 of the Affordable Care Act prohibits discrimination in healthcare. And so the great thing is that all these statutes have very similar language. And so if you just look at the logic of Bostock, it 100% applies to these statutes, to these other statutes as well, even though the only statute being considered was Title VII, which is the employment discrimination one. The other great thing about these other statutes is actually there are plenty of other court cases on those statutes that refer to Title VII's definitions of sex. And so many other courts, including the Supreme Court, have already said that if you want to figure out what Title IX means, if you want to figure out what the Fair Housing Act means, or what Section 1557 means, look to our case law in Title VII, right? And so not only is there this textual support, there are also, like just in the statutes themselves, there are also this whole body of case law saying, when courts make decisions about Title VII, interpreting Title VII, they are effectively telling you how to interpret these other statutes as well. And sort of as a practical matter, some of the reason for this is that there's just a lot of employment case law. So it's just easier for courts to say, let's just look at what they decided here, because these cases come up all the time, and there's sort of fewer, in a way, cases coming up in the Title IX Fair Housing and 1557 context. One more context I will say that in addition to statutory interpretation is interpreting the Constitution. So people may know that the 14th Amendment of the US Constitution includes the Equal Protection Clause, which says that everybody is entitled to equal protection under the law. And courts have, of course, interpreted that to mean that if a government passes a law that discriminates on the basis of race, that law is subject to what's called strict scrutiny by courts and can be struck down if it isn't like very narrowly tailored and has a compelling government interest. There is a similar test applied to laws that discriminate on the basis of sex under the Equal Protection Clause. And it's a slightly lower level of scrutiny. I cannot remember the exact language right now, but it's higher than what's called the rational basis test, which once a court says they are applying rational basis to your law, it is usually an indicator that they're gonna hand wave and be like, all right, this is fine. But if they say they're gonna apply a higher level of scrutiny, it usually means they're about to strike down your law. So it's great that we may now be getting a higher level of scrutiny under equal protections, sex discrimination protections. And this would apply to, the reason that this matters is that these other laws, Title IX, Fair Housing, Section 1557, they do apply to governments, but in these very specific areas, right? Like schools, housing, healthcare. Equal Protection Clause applies to any area of law passed by a government. So state governments, local governments cannot discriminate on the basis of race when they pass new laws or apply existing laws. And so now there's a very strong argument that they should not be able to do so on the basis of sexual orientation or gender identity either. So this is a huge, I think this case is going to have long-lasting impacts, assuming that, and we'll get to this later, we're going to talk about some other stuff first, but assuming that it isn't totally eroded away in the meantime. But I think on its face at least, and certainly in the strong language that Gorsuch included in his opinion, it's a very powerful and meaningful case for our community in terms of protecting us from discrimination. So, and with that, I'll turn it over to Keygan and Troy to talk about what this looks like here in North Dakota.
Absolutely. Thank you, Ming, because that is a great lead in. So as Ming was saying, because of the very clear language of this case, North Dakota and quite a few other states have adopted this by executive fiat is the word that's probably not appropriate here, but that's what it is, to include things like public accommodations and housing. So while those are, as Ming said, not directly addressed in the case, because of the interpretation by the executive branches of several states, they have moved to include those under existing state law. So North Dakota having done that, as Representative Boucher said earlier, for anybody that was in that meeting, that can be changed by the next executive. Therefore, it's important to continue to follow these lawsuits through and to take and codify through state law to make sure that these are completely encompassing. Keygan, did you want to add anything to? No. So, like we said, like we've been talking about all day, it's vital that we continue to organize at the grassroots and the state level to make sure that these protections are codified, as well as other protections facing our community. Because as important as these court cases are, they can also be taken away by another court. So that's very uncommon, but depending on these interpretations, you just have to cover all your bases and make sure that especially until we get very clear case law and precedent saying that they are accepting this precedent in other situations, as Ming was saying, that all these things are covered. So, I mean, that's pretty much the basis in North Dakota, except making sure that your friends and colleagues and family and neighbors know that if they are facing this kind of discrimination, if it is happening, go to the North Dakota Human Rights Coalition and to the National Center for Lesbian Rights, where Ming works, and make sure that you're telling them and getting the word out that this is happening to you or to your family members or your members of your community, so that something can be done about it. Because the sooner we take action in these situations, the sooner we finally prove that that those protections are already there, if that makes sense to you. So we were also, I believe, going to talk about the potential for bad legislation in the next legislative cycle. So one of, and Keygan, jump in any moment you want to. One of the things that we faced around the country, I say one, there's been several, but is this backlash on the trans community. So especially trans youth, through things like bills to exclude trans youth, and specifically female identified trans youth, from playing sports in schools across the country, and as well as excluding trans youth from getting much needed life-saving medical care because of discrimination based on a lot of, frankly, misinformation about what it means to be trans and what trans youth face and what the medical care given to the trans community is. So these bills have happened not only across the country, but very heavily in your neighboring state of South Dakota, and then in Idaho and other places in the region, where we are not necessarily anticipating directly this coming to North Dakota, but it is a very strong possibility, if not a probability, that you'll be looking at that. North Dakota's got a much shorter legislative session that happens much more rarely, so hopefully they're not going to spend time trying to hurt trans kids as opposed to trying to make sure that the rest of you are protected in every other way. But we shall see. Keygan, did you want to talk about these bills?
I want to point out with the bad bills too, that it is in some way a reaction back to the conversion therapy work that we're trying to do of trying to protect you from conversion therapy. They're using a lot of very similar language, especially in the anti-trans medical bills, which basically means that anyone under 18 can't receive medical care, even with parental permissions. And some of those bills were a little bit more extreme than others, depending on what state they were in. Some even went to the extent of calling it child abuse if the parents sought different, treatments for their kids, whether that be hormones or surgeries or whatever the case may be. In some cases, even seeking psychological therapy for that was supportive of trans youth was trying to be legally banned. So that it again, it uses a lot of that same language, and I always like to point out when it comes to this kind of stuff that there's always backlash to the things that we do, and it's kind of like the last dying breath of the opposition, in my opinion. But but these things have a really large impact on our LGBTQ youth. Not only if they happen in your state, but if they are happening in these neighboring states. It's important that the kids are seeing this on the media in a variety of different ways, and if a trans kid is paying attention, which they usually are, to this kind of negative things, it goes beyond the legal impact of it, and it really goes into the mental health of our youth. So being mindful of how we message around any of this, whether it's non-discrimination going in our favor, or these anti-bills that they're trying to push. We really need to be mindful of how we message that to make sure that our youth are still feeling supported.
I want to, just in case anybody's not reading the messages, we also, Michelle has put in a message that says they're working on fair housing at the Fair Housing Center of North Dakota, and are planning on doing some testing of these regulations. And Michelle's email is in the chat box if you have any interest in helping out there.
Yeah, I was actually wondering if Michelle, if you're comfortable jumping on and talking about what fair housing testing is. I mean, it's a very interesting process, and especially vital in the housing discrimination context to do testing.
Sure. Hi, this is Michelle. I think I know a lot of folks that are on the call. It's basically secret shopping, right? So we'll have a match pair testing. We did match pair testing a couple of years ago on transgender issues, and we found 90% discrimination. So it was pretty significant. That was about 2 years ago. So now that we have the Bostock decision, as a fair housing center, we can actually have standing in cases and have standing in complaints. So if we do those same tests that we did 2 years ago, we can go ahead and file complaints on them with that, based on that evidence. So as I said, it's match pair, a control tester, somebody from a protected class. They go in, they simulate a housing situation. Usually the protected class tester has slightly better credit score, income, and then we just compare treatment. In North Dakota, we have single party recording, so we can record all our tests, and that we can use that as evidence. So it's really just a great way to objectively determine whether discrimination is occurring in the state.
It's awesome. That's amazing.
Michelle. Well, I think we were gonna turn next to, I'm supposed to talk about some awful stuff that's coming down, or actually already happening. I mentioned earlier that there may be attempts to erode some of the growing protections against discrimination that LGBTQ people have. And I'm going to talk about one aspect of this kind of national or state by state. Well, actually, at this point, it's basically the strategy has definitely gone national and federal. They were doing it on a state by state, kind of testing it out. And now there is a case before the Supreme Court right now called Fulton versus City of Philadelphia, which is a case involving Catholic Social Services in Philadelphia, which seeks and gets government contracts to provide foster care services to children in Philadelphia's child welfare system. So this is taxpayer money that they are seeking out and getting as a condition of getting this city funding. The city requires all of the people receiving city funding to guarantee that they won't discriminate on a number of reasons, including against LGBTQ. Oh, sorry, I'm hearing a bit of an echo. Okay. All right, seems to have gone away. Oh, sorry. I don't know if everybody else can hear this echo, or is it just me? All right, I'll try to keep going. It's just a little distracting in my ear. Sorry. So they require anybody who's applying for city funds to say we won't discriminate in how we use this money. Catholic Social Services openly says that they will not place children with same-sex couples, and the city said, well, if you're not going to abide by the terms of our agreements, we can't keep giving you city money. Like, this is our responsibility as a city that's supposed to represent our people, and people in Philadelphia have generally decided we don't want to use our taxpayer money to fund discrimination. So they said, okay, you can't keep getting city money to do this work anymore. Catholic Social Services sued, saying that it was a violation of their religious freedom to impose this condition on them to receive city funding. So that case is now up at the Supreme Court. It's a First Amendment case. It's kind of worrisome, like depending on how the Supreme Court decides, we're all pretty worried that they'll decide in favor of the Catholic Social Services. But then there's a question of what they say. There are really, really bad versions of the decision, and then there are like pretty bad versions of the decision. I think in kind of the worst case scenario, it would basically be an open door to any religious organization to discriminate against anybody on any basis. And city governments, local governments, state governments, the federal government would be helpless to stop these institutions or these organizations from discriminating, even to the point of withholding government money. Like, it seems like such an obvious thing that the government should at least get to set conditions on how we spend the government's own money that taxpayers fund, that we should, as the people, get to say, hey, if you're going to take our money, don't do the things we don't want you to do with it. But it's possible that this case would actually open the door to like requiring the government to fund discriminatory services. So that's kind of worrying. So I'll say that's sort of the scary thing that's on the horizon. So keep an eye on that. The oral arguments for that case are going to be on November 4th. So they're coming up.
How very fitting.
Yeah, really. Sorry, the name of the case is Fulton versus City of Philadelphia. I'll put it in the chat as well. But we did want to end on a cheerier note. I think Keygan and Troy wanted to talk about the Equality Act.
You'd think after 7 months of Zoom, I would know how to use the mute button. But were you wanting to talk about some criminal justice reform issues before we went into the Equality Act, or?
We could talk about it a little bit.
No, it was in your email that I obviously on to in my time.
Sure, I'm happy to touch on that question. So, as Barry mentioned, and I think a few other people have mentioned in this summit, there's been this year, I feel like this country goes through many public reckonings on the issue of racism and the legacy of slavery. And this year we are in the middle of having another national public reckoning with on the specific, the narrow version of the topic is on police brutality or police killings of mainly Black people, but also I would say Latino and many other people of color. And as a part of that reckoning, I think the idea of abolition, which people may have heard of the hashtag defund the police, which is an abolitionist position saying that we should actually just get rid of the current criminal justice system as enforced by the police because it is just not working, as opposed to a more reformist position which just says, you know, we need to make some changes, but overall we need some kind of police, but it's just changing it to be less inequitable. So I think the current moment has shown the power that taking like the kind of moral and organizing power that taking an abolitionist position can unleash. And there are sort of similar questions on a number of fronts. So there's also prison abolitionist movements which have been around. You know, prison abolition has been around for a long time. The idea and the movement, which is the idea that we don't actually need prisons, that there are other ways to resolve the various issues that prisons claim that they are trying to resolve, like violence in our society, or you know, insecurity around our property, or, you know, things like that, that prisons are not the answer. And I'll add one more area where people may not always be thinking about abolition, which is the child welfare system. And NCLR, the place where I work, we are starting to take the position that the child welfare system is also irretrievably broken. If you look at the statistics, it's very clear that poor people, people of color, are overwhelmingly targeted by that system, and the system is not doing what it claims to be doing, which is supporting families and protecting children, but is rather separating people of color and poor people, separating the families of, poor people and people of color, and that we need some other system to deal with some of the problems that the child welfare system says that it's supposed to deal with, you know, neglect and abuse of children, or instances where children are not getting their needs met. Oh, I'll also add that, you know, for our community, LGBTQ people, and especially queer women, are also disproportionately targeted by the child welfare system, and are separated from their children, and have their children or have their families kind of broken up by that system. So I think that's another front where we're starting to do a lot more work, and it's exciting to do it with an abolitionist lens, which can help us build a lot of coalitions with folks working, you know, who are mostly focusing on or working on racial justice. But we can build some very powerful coalitions by looking at how these systems affect all our communities. So.
Am I on mute? No. Well, let's talk about the Equality Act for a second. We want to leave plenty of time for questions, but I am sure, and normally if we were in a room together, I would ask you to raise your hands, but that doesn't seem to be the best way to do things around here, that most people have heard of the Equality Act. For decade upon decade upon decade, we were attempting to pass through Congress something called ENDA, the Employment Non-Discrimination Act, which after the marriage decisions of a few years ago, we moved we moved completely into working on the Equality Act, which is much more comprehensive. It actually goes farther than many of the civil rights protections we added in the 1960s. So it goes farther on public accommodations and a few other issues, which would offer more protections. But the good news is, depending on how this election goes, just like every election, if we change the makeup of Congress, both the Senate and the House, and by change the makeup, we're both from nonpartisan organizations. So we mean get more LGBTQ allies in general, not necessarily people of either one party or the other, but making sure that we are talking about folks that believe in our issues. And truly looking, when you go to vote for your representative, as to how they talk about queer issues. If we do put a majority of allies or members of our community, in some cases, into those positions, we've got a really good chance of passing the Equality Act. And we've got a good chance of, at this point, electing a presidential candidate that will sign that piece of legislation. So I think it's really important that we think about, just as Representative Boucher was saying, when we are thinking about elections, it's important that we not necessarily think about them in terms of which party we support, like it's a sports team, but looking at those representatives on the basis of what they believe, and if their values match yours specifically, and hopefully the values of our community that we hold to be important, and that will vote for us and make sure that we are protected, because above all, they are there to represent us, and our job is to put them in place. So really look at those ballots, really think about who you're talking about. And in this particular election, that has a direct impact on whether or not we can finally, after the better part of a half century, enact these protections for our community. Keygan,
If you haven't requested your absentee ballots, do it now, immediately.
Right.
Tell your families to do it. Fill it out for them. Get it for them. That's what I had to do with mine. Literally, give me your ID numbers. I will request them for you. I will help you fill them out, and I will mail them in for you. It takes that sometimes.
Absolutely.
Are you all mail in? Like you have to mail in the absentee request. You can't. There's no online.
You can do email, or you can submit by fax, but for some reason when you mail it in snail mail, it gets there a lot faster, because I mailed mine snail mail and I got mine in a week. My friend emailed his and it's been 3 weeks and he still hasn't gotten his.
I had to, if you've had any change of addresses or name change.
He's lived in the same place for 3 years.
Oh yeah, one thing I learned is I moved and then all kinds of things hit the fan, but I actually called down to the actual registrar's office, and she literally guided me step by step, changed my address and everything else. And what was cool is I did it for the mayoral campaign up here in Grand Forks, and then out of the blue, my ballot for president just showed up at my door. So she just asked at that time, do I want to do for the presidential as well? And I was like, yeah, heck yeah.
And there's the form for your convenience.
Thank you, Keygan. All right. Well, I'm hoping that y'all have some questions for us. Ming went over a lot of information.
Sorry, I have a tendency to.
It looks
No. I appreciate it. It was good information. I think
There's
Ming has another one for you.
question in the chat. Says, do you know or could you get info on the ramifications of Gavin Grimm's case as it stands and what it may mean for students in North Dakota?
Yes, sorry, I have to remind myself how that case ended up resolving. Sorry.
It's I just so y'all know, we are very much experts in our field, but we're not experts on it. We will try to get you as much information as we can.
Yeah, let's see, because they sent it back down to the 4th, and then what happened? Let's see.
The Grimm case, it was a complicated one because it went back and forth between several courts.
Yeah.
So
I think Bostock will certainly help to resolve that case if it hasn't already fully resolved. Let me see. Okay, it looks like the most recent update, I'm just looking on the ACLU's site to see their updates on the case. This is an ACLU, sorry, to give people background, if you don't know what this case is. Gavin Grimm was a student. He's since graduated from his school. In Virginia, he is a trans, well, now he's a trans man, he was a trans boy. And his school refused to let him use the bathroom consistent with his gender. They were forcing him to, among other things, sorry, this is not the only issue. So as a result, he, with the help of the ACLU, sued the school. And so the question was, does Title IX, which is the federal law that we mentioned earlier, that protects against discrimination in education on the basis of sex, does that protect a transgender student in this way, from this kind of discrimination? And it went up and down, the appeals, all the different levels of the appeal. It looks like most recently he won, back down at the district court level. So, but because that was a Title IX case and about the definition of sex under Title IX, I think Bostock probably, if it hasn't been fully resolved at this point, should help to resolve that case in his favor. So. And then as for what this means for students in North Dakota, like I was saying, like Troy and Keygan, I think, would agree. And Troy also said, you know, if you see this discrimination happening, do something about it. Contact us or make a complaint with the North Dakota Department of Labor and Human Rights. They enforce the state anti-discrimination law, and that agency, like Troy said, has taken the position that North Dakota's own state laws prohibiting sex discrimination, because in light of the Bostock decision, they will be interpreting those laws to also cover sexual orientation and gender identity. So the most important thing is to just speak up and do something about it, I think, and to act like you have those rights, which we think you do. I mean, right now there's very strong arguments that you are protected, and so the question is just acting like you are. So.
Right. Who else has a question? There we go. When future cases like Grimm come before the court, what will the opposition argue to convince? Oh, there you go. That's all yours too, Ming. Sorry.
I know, it's so funny. In my organization, I'm the person who does the least litigation. So usually I defer to other people to answer these questions. But I guess on this panel, I'm the closest to a litigator.
I mean, I've got a law degree too. I could take a guess. I would just, in the realm of guessing, I would rather you do it.
Well, I'll tell you some of the arguments that people, we don't have to guess. Like, they are making these arguments now. One big attempt is, like I said, the religious freedom arguments, right? Saying that, but of course this is only open if you are claiming that you're discriminating based on some sincerely held religious belief or because you are a religious organization. There is another line of arguments that people are trying, which is to what's called distinguish their case from Bostock, meaning no, like either this particular law is significantly different or our particular set of facts is different enough from Bostock, like for example, trying to argue that Bostock is only limited to the employment context or only limited to firings, right? Like it is true that all three cases being decided in Bostock involve people who were fired. But the reasoning of Bostock, I think, is very clear that it applies to way more than firing. Or to say, sure, we shouldn't discriminate against against students on the basis of sexual orientation or gender identity, but this thing that we're doing isn't discrimination. Like that's another kind of argument people are making, like requiring trans students to use the bathroom that, according to their gender assigned at birth isn't discrimination. It's just a neutral policy that applies to everyone. Non-transgender students also have to use the bathroom that matches their gender assigned at birth. So those kinds of arguments, I mean, I think a lot of them are pretty dumb, but they are being made. And there's a worry that as if the composition of the Supreme Court changes significantly, Supreme Court has given credence to a lot of dumb arguments before. I'll just say that if you look at the history of this country. So, yeah.
I mean, it doesn't have to just be questions, folks. Anybody have a comment or?
I was really surprised with the Bostock ruling, the amount of even conservative justices who ruled in our favor. I remember when I was reading the justice actually rulings, I was like, I think even Kavanaugh voted in our favor, didn't he?
No, but when he did some arguments that were
his argument, yes, it should have been made in Congress. That's what it was. Right.
So
that one struck with me, and I think that was his only reason for voting no.
I think yes, absolutely. As a lawyer myself, and I'm sure Ming, I hope will agree with me, maybe not, but jurists are not necessarily politicians. So just because you've got a Supreme Court justice that's nominated by a Republican or one that's nominated by a Democrat does not mean that's where they're going to come down on the law. If you go back and read through case history from each of these judges, if you look at Gorsuch, this wasn't a surprise to me, but even more so the one that people were surprised by was there was the Creek Nation. There was a lawsuit with the Creek Nation, got half of Oklahoma back basically. as far as jurisdiction on criminal cases. This should not have been a surprise to anyone because it was so clear in Gorsuch's body of work. But the same can be said for most justices. It's not a ideological, most of them, mind you, don't come with an ideological framework. Most of them do come and they'll look at a case. Now, that's not to say when there's ambiguity in the law, their personal ideology isn't going to come into place, but there just wasn't a lot of ambiguity here. I know a lot of people didn't see it going this way, but that's because they read too much into the tea leaves of what these individual justices believed in their personal political lives. But looking at the law, and Ming, I'll let you finish on this. I just think it was a very rational decision based on the body of work from all these jurists.
Well, one thing I noticed too is that if you look at the voting history for most of our Supreme Court justices, is they kind of like stray into the middle the longer they're sitting. Like you have no choice but to be objective in that position, I'm sure.
Right. Well, and they can't kick you out without impeaching you. I mean, it's not like once they get there, they're there. And it's
life.
not.
You could quite literally die sitting in your chair.
Well, some of them have. Well, I don't know about in the chair, but in a chair. But while they were theoretically looking at cases, probably. But no, that's the whole point of having lifetime appointments to the Supreme Court. Whether I personally believe in them or not, what can be said about it is they're not governed by the next election, and they can do what's right, even in cases where it might not be necessarily popular opinion. Now, that's not to say, and one of the reasons we work towards on conversion therapy and before that marriage, to build this body of electoral wins, or legislative wins, I apologize, is because the courts also do look at the way the law is going and what their overwhelming support for something. They do look at that because that also sways the opinion. They don't want to make huge fundamental social change based on a decision. And in a case like the marriage case, it was the opposite. The fundamental change would have been to strip all these marriages back, not to allow them to go forward. So sometimes it is the role of advocates and activists to create, and lawmakers especially, to create that body of law throughout the country and that movement to make sure that these laws are protected, or that these folks are protected. I think a lot of the Bostock decision, not only was it the right thing to do with the law, it was the right thing to do in the way the law is moving forward in state legislatures and municipalities around the country. I mean, it's important that public perception be shown to these justices, even though that's not really their job. Is to look at the law, but their job is also not to hurt people.
Yeah, I think that's a great point. Oh, I see it. Maybe a question, but I was going to say that's a great point, Troy, and like just points to the fact that lawyers and courts are we're like the last thing to happen in any movement struggle for like full human rights and dignity. Like the first thing that needs to happen is the community and our allies need to be pushing for a changing of societal norms. You know, like courts change long after societal norms have changed. And if a societal norm has changed, like very completely, there's actually very little that the courts can do to push back. You know, these anti-discrimination laws, even if they get eroded, I'm not to underplay how important these laws are to protect people, but it's just as important for us to create a social norm of, you know, discrimination against LGBTQ people is totally unacceptable in our society. And if you do it, you are the outlier. You know, if you engage in this kind of behavior, like this is not something most of us approve of. And I think once we've really gotten that social change, these anti-discrimination laws will just be sort of additional protection as opposed to kind of how vital they are right now, because we're still in transition on this question socially.
So Faye asks, while we're looking at administrative changes to prohibit conversion therapy bans, or to ban conversion therapy is what I think the question is meant to be, in North Dakota, will there be a right time to look at legislative change for this, and what does that look like? Well, there's a very specific reason why we don't want to why North Dakotans who are or thought leaders and lawmakers don't want to necessarily introduce legislation. North Dakota is very specific in the fact that there are votes required on legislation that is introduced. You don't have that in a lot of states. So what would happen while we have this window to look at this ability to change the regulations, interjecting that into the political process at this moment would add a different element of legislative intent that's not there right now. So because these legislative bodies feel that, and when I'm using very specific language because they've got the right to change these things, but they have by norm always looked to the legislature, and if the legislature doesn't want to do something or does want to do something, they give that to the legislative body as legislative intent. If we were to take this opportunity for potential regulatory change and interject legislation in right now, it would take the impetus off of those regulatory bodies and put it onto the legislature, where what is right now a human rights issue would become a political issue and change the dynamic of it. So I think to answer your question in a shorter way than I just rambled on about, after the current round of mandatory regulatory changes happen, is a good time to look at a stronger legislative ban, if that makes sense.
Could I ask a different question? Do we have time yet?
Oh yeah, they got
Okay.
a yes, thank you. So Faye's question is answered.
Good. Say we have had. I'm in Bismarck, and I was a part of helping the Bismarck Public School System rewrite their strategic plan, and the Grimm case was on my mind when there was the discussion about inclusion, and whenever you specifically speak with leaders about non-conforming bathrooms, you get a lot of resistance. But there was a lot of general, broad statements about all students being treated equal, and it's in writing. So my question to you guys is, so it's not a law, it's, you know what I'm saying? It's like, this is what our belief system is, this is who we are. How do you hold the leaders' feet to the fire when they've put in writing that all students will be included? Any thoughts on that?
Before you answer that, we have about 4 minutes before
Thank
we
you.
get jerked back to the other room.
Great, thank you, Linda. That's a rough one because you're absolutely right. There's no real legal standing with any of that, and so you can't push it from that perspective. I think you do have to push that from a grassroots perspective, unfortunately. But there's power in that, right? There's the ability to say, you know, these issues are going to keep coming up, and so we need to address them as a community and as a school culture and community space. And you're saying that this is important, and I think always utilizing one's language back and saying, is this actually what you mean? And if it's not, that's okay. Like we can talk about whether or not we really mean that, but like if we don't mean it right now, then we need to change that. So like make up your mind kind of space, and putting that in front of people is I think a really good strategy, because then people have a tendency to go, well, no, I do mean that. Okay, well then how are we showing that? And starting small, you know, I know, particularly for teenagers, this is like, I work at a trans camp every summer, and this is one of the things that I have to tell them all the time is I'm like, sometimes you have to take the small win and then run with it. And so, you know, if we can get a single stall gender neutral bathroom on campus that anyone can use, not just trans students are relegated to that, but anyone can use it, that's progress, right? Like it's not ideal. Yeah, in an ideal world, we'd have the bathroom situation open to everyone, but it's a step closer. So if you can start to get like those small wins, if you can get, you know, a history teacher to start to talk about LGBTQ history in their classes, despite the fact that it's not part of the general curriculum. You know, if you can start to build those little pieces, I think your school systems have a tendency to shift on their own.
I'm going to stop us at this point, and I want to thank Keygan, Ming, and Troy for your contribution today. And if you are ready to leave the room, you can go down to the bottom of the page, the right-hand bottom, and click Leave Room.